We have several examples that we're going to go through and get your input on how we deal with these things. And this first example is about Mega Company. It's the day before the annual shareholders meeting at which the press will attend, and an important vote will be taken on your company's future. You are responsible to make a presentation on the new engineering designs to be developed during the next year, a key to the company's future. This presentation will be critical to the shareholders' vote. The team from the graphics art department has spent weeks preparing a fantastic PowerPoint presentation for you, including a lengthy video from a PBS program and a Beatles song playing in the background. They preview it for you, and you think it's about the neatest presentation you've ever seen. It very powerfully presents the issues the shareholders are going to vote on. There's a handout you can pick up as you get in, if you'd like. You check and you find that no effort was made to obtain clearances for the sources used. The shareholder meeting begins at 7 p.m. tomorrow. What do you do? Any ideas?
Try to get clearances.
Okay. So you call the whoever it is that you would call. You've got 24 hours to figure that out, and you think you'll be able to get a decision from them by tomorrow at 5 o'clock or whenever you're 7 o'clock. That's an approach you could take. And if you don't get the clearance, then what are you going to do for your presentation? Now that you've told everybody that this is what you wanted to do, and you go ahead having told persons that you don't have permission to do that, but you go ahead and do it anyway, you're going to take that risk?
Well, I mean, I don't know. I would do that while trying to maybe reschedule.
You reschedule the board of directors meeting, the shareholders meeting that happens once a year? Good luck. You have 24 hours to reschedule. This is a large corporation with all kinds of notices. The shareholders meeting will happen as scheduled, regardless. The question is, what are we going to do about the presentation? Any other ideas?
Remove the copyrighted material from the presentation.
That works. That works. That will detract significantly from its effectiveness, but the graphics art people have 24 hours to amend their ways. Any other thoughts?
For the video program, you could use it in the most powerful clip of whatever. I think it's like 30 seconds you get without infringing.
You would use a small amount and claim that it's a fair use?
Yeah.
Yeah, I don't think there's any time limit on that, but I think that's an approach. If in fact it's not very much, but this hypothetical is a lengthy video, and yours is a compromise. Instead of removing the entire video, find the best part of it, claim it's a fair use, and then you've got a defense. That's an approach. Any other thoughts? Yeah?
It's kind of weird, but you get a cover band, like a small one, and pay them to play the Beatles song and use that?
Well, you could do that, but you'd have the same copyright infringement problem of performance rights. And so that doesn't really get you around the copyright problem. You just convert it from one copyright infringement to a different copyright infringement. So that wouldn't really advance too much.
You just pick another song that's not, no longer under copyright.
Pick a public domain song and put it in the background. Sure, that's an option. Yeah?
Can you cite where the material was drawn from?
You could do that. Our thanks to the owners of whoever it is, which we haven't figured out because we haven't had time, I suppose. That would be a little bit awkward.
So you're saying that you don't even know the source of
I just found out right now that they didn't have clearances. It's tomorrow at 7 p.m., some presentation's going to have to get aired. So we've got this time pressure that it's forcing us to do something. Okay, anybody have any further thoughts? What about the practical realities? In theory, of course, if you had a month and you saw this in advance, sure, go through all the clearances, you've got time. If they don't give you permission, great. Practical realities are you cannot do that. There's not enough time. The system is not set up to let you do that. There's another factor that is of some relevance in the real world, separate and apart from the copyright rights. This particular client is a benefactor for public broadcasting, donates substantial money every year. What are the odds of public broadcasting filing suit based upon this one use in this particular situation? Particularly under the circumstances. And so that's a factor that you could take into account as well. Even if it's technically wrong, the practical realities are that public broadcasting system is not going to sue a company that donates large amounts of money to their operations on account of a one-time use because they didn't properly get notice, provided that you adopt procedures so this will never happen again. And so that's an approach that could be taken into account as well. All right, let's look at another one. Independent inventor. While sitting in Mackey Arena watching a basketball game, the roar of the crowd leads you to think about a possible sound reduction technique, and you theorize that by making alternating rigid and flexible foam damping layers that will cause sequential acoustic reflections between the layers, you can greatly reduce the sound transmission compared to prior designs. What do you do? Come up with this great idea? What do you do when you come up with a good idea? What's the first thing you do?
Document it.
What?
Document it.
You might. It's not the first thing I would do, but that would be a good thing to do first. That's a fine thing. Anything else? Yes. You search. That is the most important thing, because if you search and you find the identical thing in the prior art, there's no point in documenting it, because somebody else already did it. So the very first thing that you do, anytime you come up with any invention, is to do a search to see whether it's really new, and to the extent it is new, how different it is from what other people have done. Okay, what's the next thing you might do? Search, then maybe document. What are the options that you could do? Any ideas? You could file strike provisional, file a patent application. And particularly when we are entering into the world of first to file, the earliest to file tends to get the best rights. The earlier you file, the better your rights are going to be. So that is the next thing to do, is to file a patent application. Whether it's to be a provisional patent application or a full-fledged regular application is a matter of more complex analysis. But in any event, you want to file a patent application as the next thing. Because filing the patent application is what's going to more firmly establish your rights than anything else that you can do. It is the ultimate form of documentation. Because it's not only documented, but the government has certified that in fact it was documented as of the date of filing. And so if you have it all in your mind, you write the patent application and you file it the next day, that's the perfect world. You come up with the idea, you do a search of U.S. patents, presumably. If you can't find it in U.S. patents, then you try to write patent claims and write the rest of the patent application based upon what patent claims you've written, and then you file your patent application. Mini company. You are employed at Mini Company, Inc., a widget manufacturer. Joe Smart, a friend of yours from college, suggests to you an idea for an improved widget design. You think it is a neat improvement and would like to incorporate it into your design. You doubt that Joe would file for a patent on his idea without your encouragement. What do you do? Really an interesting dilemma that happens from time to time.
How good of friends are you with Joe?
Excuse me?
How good of friends are you with Joe?
Really good friends. Because he's from Purdue, right? He's a friend of yours from college. So, has to be a good friend. So, Boilermaker, just like you. Yes.
Well, if Joe is suggesting this to you, then that's kind of like saying he's giving you an idea to use, right? Otherwise
He would love for you to use it so that when he gets his patent, he can sue you for infringement.
It's not that good of a friend.
Huh?
It's not
Oh,
that good
well,
of a friend.
yeah, and maybe he wasn't thinking of that, but the company that he has an obligation to assign his inventions to might have a different perspective.
So we know it's not in the prior art.
Doing a search is ideally the best thing to do, because the moment that you find it in the prior art, you know that your friendship is intact and you don't have to worry about who's going to own what rights. So absolutely, doing a search is the very best thing you could do first. Because until you do the search, you don't know whether this is worth arguing about or fighting about or whatever else to get in the way of a friendship that might be there. Yes?
Can you file a patent application together?
You cannot file a patent application as an inventor if you're not an inventor. Now, you might be able to negotiate with him an arrangement so that you would get license rights or you would be a co-owner of the patent. And in that sense, you could sort of file it together. But it's only the inventor who has the right to file the patent intrinsically. He can assign part of that right to you if he's your good friend. Maybe he'll say 50-50, no problem. You pay for the patent, it's my idea, that seems reasonable, and good luck. And you can work out that kind of a deal, and that's a good idea to do that. Do you raise the issue with him? You doubt that he would file for a patent without your encouragement. You know, if he never files for one and you go ahead and use it, then... But then we get back to how good a friend is he? And are you going to tell him, you know, is that a good idea? Do you care if we use it for free? If he says, no, go right ahead, then that's fine.
But then that would not prevent from somebody else developing this.
It would not. It might not be the best outcome. But at least it gets you off the hook of a potential infringement later on if he gives you consent. And it can be oral, his agreement to let you use it. Ideally, it's in writing, but it doesn't have to be legally binding. You might talk to your boss at Mini Company, Inc. See what they might suggest, because your boss may say, you know, if we've got to deal with some third party, we don't want to be involved. They may have some policy that would be either in favor of or against. So certainly, getting your employer involved would be something to think about. But then, if you're going to get your employer involved, it's a little awkward if your employer might want to acquire those rights. It's a little awkward if you've got a deal where you're going to get 50% of those rights, and you got those rights negotiated before you talk to your employer. Because that could be argued to be a corporate opportunity that you're taking away from your employer. And they may not appreciate that you first acquire a 50% interest and then go to them and say, would you like to buy what I've now gotten a chunk of for your business? So that might not be such a good idea if you have any thoughts that your employer might want to buy these rights.
But wouldn't you be obliged to your employer to give them, I guess, the rights to it if you were developing this while working there?
Oh well, but this is not something that you've yet incorporated into your design. You want to, but you haven't. Certainly, if if you incorporate it into the design, but you're still not an inventor, so what rights are there other than the trade secrets that flow from your own specific application? The patent rights are owned by Joe, if anybody.
So Joe doesn't work for many companies?
No. No, Joe is a third party. He's out there with this idea.
So couldn't you wait a year from after he disclosed it and then do it, since his patent rights would be expired?
If he didn't file in the meantime, if you're sure he didn't file, but I don't know whether that year delay would work with your time frame for your current design that you want to put it in. It would seem to me like you'd want to talk to your boss before dragging your feet for a year on the project you're working on. So I think you'd need to get that sorted out. Well, I think this is a very difficult dilemma as to how you deal with these kinds of things. And each situation is somewhat unique, and as one suggestion was made, it depends upon the relationship that's there. How close a friend is he? Is he just an acquaintance, or is he your best buddy from school? But you really cannot acquire the patent rights without involving Joe. And if he's any kind of a close friend at all, you'd hate to just, you could just go ahead and incorporate the idea in your product, and if he files for a patent, then settle up later for whatever patent infringement risks there might flow from that. Of course, the first thing, as always, is to do a search to make sure, in fact, that this is something that's worth fighting over, that could be patentable. If it's not patentable, then there's no sense even worrying about it. Okay. Tiny Company. You would like to start Tiny Company Inc. by manufacturing and marketing a substantially improved gadget. The earlier designs made by Gadget Inc., the dominant player in this field, will be free of patent coverage in about 4 years. And you are convinced that your improved designs could take a substantial market share from Gadget Inc. and would be very profitable. You note that the soon-to-expire Gadget Inc. patent claim 1 reads on your improved design. What do you do? Okay, what's the first thing we almost always do? Yay, search. Because, and what are we going to search for? What are we looking to search? We're going to look for prior art for our improved design, because if we find that very thing in the prior art, we're done. And we don't have to worry. But, of course, this particular question, it says that it is a substantially improved gadget. So that suggests it's not in the prior art by the given question. What else might you search?
Can you search if the patents from Gadget Inc. are violating any prior art claims?
You certainly can search to see whether patent claim 1 not only reads on your improved designs, but might read on some prior art that would make it invalid and thereby allow you to ignore patent claim 1. Because if you can find prior art that claim 1 reads on, even though it doesn't affect your ability to get your own patent on the improvement, you can then ignore Gadget Inc.'s patent claim 1 and proceed right away with your new company. You don't really care that they have a patent, because that patent claim 1 is invalid because you found it in the prior art. Now, if you can't find it in the prior art, then what do you do? Can't find anything in the prior art for either your invention or Gadget Inc.'s patent claim 1. Okay, license. What's your suggestion?
Try and sell your idea to them for a while.
Okay, so right now you could sell idea We're assuming the searches didn't pan out, so we're stuck with claim 1 being valid, and we're stuck with, or with the benefit that our own okay, selling your idea to Gadget Inc. Gadget Inc. is really the only company you could sell it to as a practical matter because they've got the dominant patent. So it would be 4 years before anybody else might be interested in buying that patent unless they're really a speculative investor. So as a practical matter, you have to sell the idea to the only company that could really implement it right away, and that would be Gadget Inc. You could sell it to somebody else, but that would be tough. And then there was a license suggest. Tell me about the license. From whom, to whom, for what rights?
Well, it could probably go either way, right? If you filed an improvement patent, then you could try to license your patent to them.
Right.
Or else you could try to license their patent.
Okay. License to Gadget. Okay. Or from Gadget under their claim 1. And that license would only be for 4 years. So that is a little more manageable. The license going the other way would presumably be for the life of your patent on the improvement, which might be 20 years. Okay? Any other options? Suppose they say, I don't want to license you. I don't want to take a license under your improvement. Go away. You've done a search. You can't find prior art to invalidate their patent, so it looks valid. So
you can always just wait 4 years.
okay, we'll wait 4 years. Okay, what do you do at the end of 4 years?
File a patent on your improvement.
Why would you wait 4 years to file a patent? Is there any reason why you can't file a patent right away?
Just because it's because the prior art of Gadget.
The prior art of Gadget Inc. has no bearing on when you file a patent on your improvement that's not shown in their prior art. It's a completely independent question as to this improvement that you've made, the substantially improved gadget, isn't shown in Gadget Inc.'s patent, so it doesn't get in the way. And the expiration of a patent doesn't make it any more or less of a piece of prior art than if it's expired or if it's in force. It's still the same prior art. Either way, it's going to be prior art as of its filing date, at least of its publication date. Yes?
Are damages awarded based off of like the market share you took or your sales? Because a startup, you're probably not going to have that much sales. You could just take the hit, take the damages.
Just go ahead and infringe.
Yeah.
Okay? You could wait, or you could infringe. Okay. So let's look at the infringe consequence. If you infringe, it may well be that they would file a lawsuit against you. And we've already sort of assumed that you've done your search and you haven't found any prior art. The hypothetical says that their claim reads on your device. One thing that you could do along that line, but let's infringe is one thing, but how about seeing if there might be a design around? There might be a design around that could still take advantage of your improvements, but might avoid claim 1. So if you do some engineering work, you might come up with a way that avoids their patent claim, but still gets the benefit of your improvement. And so that would be a way that's not waiting. You could put the new features of the design around in the patent application that you're filing on the basic improved concept, and maybe get an extra bonus by some extra design work. And it may be that you can come up with this design around, and that would be an ideal approach. If you go ahead and infringe, the problem there is 4 years is enough time that they're probably going to be able to get through a lawsuit, get an injunction against you, and put your product off the market after you've built up your market, which is really catastrophic for your business. They'll be able to get all your profits or 3 times their damages because your infringement is willful, because you knew they had a patent and you did a search and you couldn't find any prior art and the claim reads on your product. What's your defense? It isn't a close case. So you are likely to have to pay treble damages, and you might even have to pay attorney fees for the other side as well as yourself. So that's a very expensive alternative, given that it's 4 years. If it were 1 month, fine. Take that risk. You've got some logistics in there. But 4 years is really quite a long time. And that's really the problem. The damages could be obtained. They could well be able to get an injunction against you. There's no guarantee that they would, but the odds are pretty high that they would on these gadgets. They're not some life-saving thing where people have to have this improvement in order to live, so that there'd be equitable considerations as to whether or not an injunction should issue. So you've got these 3 things. But the important thing now, those are 2 options, but always you're going to search, and always you're going to, assuming the search is favorable, file a patent application. Now, whether it's a provisional or a regular one is secondary. I don't really care, as long as you preserve your filing date. That's always what you do in virtually every case where a patent is in question or an invention is in question. Do a search. If what you've come up with is quite different than what you find in the search, then file a patent application to protect your rights. And the sooner you file the patent application, the better off you're going to be. Okay, next. You've just finished your move to Tucson, Arizona, and you've arrived at your first day of work at Acme, the company you've dreamed about working for. Acme is the world leader in helical gear design, an area you've been passionate about since your youth. The charming human resources host provides you with forms to fill out, and you note that one provides that you promise not to work for any other company in the design or sale of helical gears for 1 year following termination of your employment at Acme. What do you do?
Try to renegotiate.
That's a very good suggestion. How close was it that you got the job or didn't get the job, and how will it look to your brand new employer that you're trying to renegotiate this? First of all, the question is, what state are you located in? Okay.
So is it even legal for them to do that?
Yes, it is in Arizona. It is not in California, the singularly significant state where these are not enforceable. Okay, so negotiate. Any other thoughts, or how would you go about that?
I guess I'd want them to define exactly termination, if it was my willful leave, or if it was you got fired.
Okay, so that's a variation in the negotiation. That'd be pretty hard to put in writing as to whose reason it was. That could set up some really awkward dynamics within the company and your employment, where you would try to make it look like they fired you or whatever. You could do something then with fired for cause. Does that get you out of this, or does it have to be without cause? Or do we want to make this really complex to figure out what all the rationales were for your termination? as to whether you're going to have to sit out a year from working on your passion since youth, these helical gears that you really care so much about. What else might we negotiate?
Some terms for that year, some benefits that you might receive for staying out of the market.
Ooh, I like that. That's really good. That's fine. I'll stay out of the employment for a year if you pay my salary for a year. That's fine. No problem. And I'll even agree that if I get some other job that pays more, that I'll forgive that. But if I can't, and you're going to keep me sitting and cooling my heels for a year, I want my full pay for that 1 year. And that's fine. If it's really important for you not to have me working in this field for a year after I quit employment, then just pay me for that year. And that would even be upheld in California, where you got your full salary for that year that you're waiting. Might be enjoyable as well. But you need to raise this issue. You need to read the papers. And I suppose you could consider just signing it, not saying anything about it, keeping in mind that you might consider your next job involving helical gears to be in California, where these consequences cannot be so well enforced. If that's a personal option, you could consider that. You'd want to get some independent counsel to make sure that will work, but that's an option you could consider, to just sign it, not make waves at the time that you're starting out. Figure that's something you can renegotiate later after you've gotten some trust and respect from your employer later on. Any other thoughts?
Is that enforceable? So you're saying like it's legal in Arizona, but say they have like another office in California, you got transferred there, they still apply then?
Certainly would not.
So you could look to transfer them.
So you could look to transfer to California in their California office, and then while you're there, when you quit, then it's not an enforceable provision. Because California would not allow that to be, assuming your next job is in California as well, you have a California court to involve you there. Okay. You and 3 others at Engineer Inc. are frustrated with management's lack of management skill and business sense. Although Engineer Inc.'s 75 employees seem to be doing fine in maintaining the past quantity of engineering services business, your group of 4 think that if you were in charge, you could really make a difference in the success of the company. You decide to consider leaving as a group and starting your own competing company. You would like to ask Engineer Inc.'s major customer whether they would divert business to you if you set up your competing company. What considerations do you need to take into account?
Any sort of trade secrets that engineering has with you?
You'd have to make sure that if you left and went to a new company that you started, you wouldn't take any of the trade secrets. That's good. You have a contractual obligation to your employer, even if it's employment at will without a specific contract. You have an obligation to your employer to maintain the trade secrets, as was mentioned, and there may be some other provisions that are in a written agreement that you'd want to take into account. But the questions posed is, can you ask their major customer whether they would divert business to you if you set up a competing company? Nobody knows. The mystery. The answer is unequivocal. No, you cannot. While you are in the employ of your employer, you are not enabled to divert customers directly or indirectly, or even find out if they would be diverted. That's not permissible while you're in the employee. You have a duty to your employer for as long as you're employed. The second after your job quits, you can do whatever you want with regard to those customers. But you can't work out in advance an attempt to divert prospective customers or new customers until you've terminated your employment relationship. Because until that's terminated, your obligation is to your current employer. Well, what can you do? We know what you can't do. What can you do?
Did you ask them if they're satisfied with Engineering Inc.'s?
Sure, as long as you're doing that to make sure Engineering Inc.'s customers are being well taken care of. You're doing it for the right reasons, sure. That's what you probably should be doing anyway, no matter. So you certainly can do those. But suppose you've got this business you want to set up. What can you do? Can you rent office space? Get that already? Sign leases? Can you form a corporation? Can you get investors to put money in your business before you've quit your job? The answer is yes. You may do all of those things. There is much that you can do. You just cannot divert the corporate relationships that are there. But to the extent you're just setting up your own business and not actually starting your business, but just getting it all ready to you can hire secretaries, you can hire lab technicians, you can hire facilities, you can hire equipment, you can buy equipment and install it and get it all ready to run, but you can't start competing with them. You can't start selling product until after your employment relationship quits. So there's much that you can do, but you cannot violate the customer relationships that your current employer has.
So does that go right up until the product's available to be purchased? So you can start manufacturing, have the whole product line ready?
You could actually start manufacturing, I believe, as long as you didn't tell anybody and offer it for sale. You wanted to build inventory, I think you could do that.
And then the day you quit, and then I guess you're now no longer employed,
then you can call up all those people that you talked with and that you knew personally and whatever else. Now, you can't take a list of customers from your former employer because that's the trade secret that we have to respect. But you probably remember all their customers because you work for them and you know them and probably know a lot of them by first name basis.
So what's the distinction?
You can't take a printed customer list. To the extent you remember and have relationships with people, you can use those in your subsequent employment. But if they have 5,000 customers that they send on a mailing list, you can't take that mailing list and then the next day use that mailing list that you got from them. Usually, a company's customer list can be replicated by public lists of addressees from organizations, societies, whatever, that you can get the lists from without violating the trade secrets. Usually those things are generally public, and so that usually does not present a problem if handled well. If not handled well and people are sloppy and they actually take those pieces of paper that have those lists on them, then they can get in trouble. Okay. Very Large Motors, Inc. You work for Very Large Motors as an engine designer. You have developed some very interesting and fuel-efficient designs of valves which can improve fuel economy 13% and reduce manufacturing costs 20%. The Society of Automotive Engineers asks you to make a presentation about valves in their upcoming international convention in 2 months. Your best friend from Purdue, now this gives the hierarchy of how close a friend he is. It's your best friend from Purdue and former Physics 172 lab partner calls saying he is enjoying his job at Competitor Motors and wants to talk to you at the convention about valve designs since he was asked by Competitor Motors to come up with an improved valve design. He says he has a really great idea about how to improve valve designs. What all can and should you do? This is starting to get easy, right? What's the very first thing you're going to do? Yes, a search. You're going to first search to make sure this is worth all this mental anguish. You're sorting this issue out. If you don't do a search, you're going to spend a lot of energy oftentimes that's wasted. But let's assume you do the search and you can't find any prior art to your idea. And you can come up with lots of ideas to tell your friend that's in the public domain. What do we do? Do you say, yeah, I'll meet with you, be happy to talk with you?
No, because then if his thing turns out to be similar to yours, you're going to give a presentation over it, and then he's going to think that you're stealing his idea.
Would it make a difference whether or not you had filed your patent before you talked with him?
Yes, you should.
Because it would be really hard for you to steal his idea and have it in a patent filed before you had your discussion with him. So that's a good reason to have a very early filing. After you've done your search and you find that you're clear, to then have the discussion with him. And then the question is, will your boss say it's fine to tell this engineer at the competitor about this new idea, or will they want to keep it secret for as long as they can? So you might need to get clearance from your boss.
Is that clearance to talk to him, or to do a patent application?
Well, no, I mean, he doesn't need to be involved in the decision for you to do a patent application. That's up to you and your boss. If you want to file for a patent, it's your idea. Now, he's got some ideas. You don't know what they are yet. But at least you should get your patent application on file, particularly that first to file is what rules. And you have a duty to your employer to file as soon as possible so that you'll have priority over anybody later filing.
But then if you're attempting to keep your design as a trade secret instead of filing a patent, then should you not meet with him?
That's a business question. But most inventions in the automotive field can't really be kept a trade secret because they're going to be in the vehicle that's sold, and you can look at them and say, oh, that's what they did. And so the trade secret component tends to be a lot less significant here than in chemistry arts, where you have catalysts and you can have secret processes that people can't tell. Now, it could be that there's a manufacturing process that you could keep secret that would be in the automotive arena. But most likely the patent system is going to be your form of protection, and so that tends to be a lesser concern. Any other thoughts?
Use a non-disclosure agreement?
That would be a good idea. That would be a good idea. So that you could tell him and you would preserve any trade secrets that are there. Now, whether he would want to sign a non-disclosure agreement, if you've already got your applications on file, that might cloud the clarity and purity of his own patent applications, but that would be his choice. And of course, he's your best friend from Purdue, and so you don't really want to get him in trouble. And so you might say, I'd love to talk to you. If you can get your patent applications filed, I'll get my patent applications filed. Then we're pretty much secure in the exchange. And then if we each see that the other has come up with good ideas that we could help one another with, then we'll have to go to our respective corporate entities and see whether there can be some negotiation for cross-licensing or some other arrangement. But having the non-disclosure agreement preserves rights in any further improvements that might flow from that interchange. It may even be when you get together, you'll come up with a joint invention that was both of yours, that both companies will own rights in, and then you'd have to deal with that. But you'd want to get your employer involved once you're going to have that kind of exchange. Now, we'll also say that a lot of times in business, this happens at the business level as well as at the engineering level. There are some low-level informal exchanges that are somewhat off the record that happen almost inevitably in virtually every field of technology. And that may well happen, but at least at the highest level, we're assuming that everything is rigorous and done by the boards. But that's another factor, that sometimes there are exchanges back and forth that are informal, and that's a question of custom of the particular industry and how well that kind of exchange is tolerated and accepted in that particular niche of technology. In some disciplines, it's not at all. And certainly, to the extent you're working on government classified information, you don't informally exchange that classified information with anybody for any reason because of some exchange that you're expecting. And in some industries, there's a very rigid protection of secret information. In others, it's much more casual, and you'll just sort of have to find out what the custom is in the niche that you're working in.
Going back to the presentation at SAE,
Mm-hmm.
you then prepare your presentation and then give it to your boss and maybe your lawyers at your company to make sure that you're not giving out information that they're uncomfortable.
If you're in that rigorous type of business, but almost always companies, when you're making a presentation in an arena that they're filing patents on, they want to see those presentations, because there can be things that you would say in the presentation that you might not appreciate would have an impact on the patent coverage, and the patent lawyer is going to want to maybe take a quick glance through to see whether there's something you're saying that maybe could be put in the patent, or if the patent's already filed that you maybe shouldn't say because it might compromise a position that the patent is trying to assert. It's routine in a lot of industries that all publications are reviewed by counsel for publication. Okay, Rapid Grow Company. Rapid Grow Company is a leader in bicycle design. And it sent you to visit Buy Me Inc. to look over their business to determine whether Rapid Grow should acquire the bicycle business of Buy Me. The attorneys for the two companies signed a non-disclosure agreement requiring you to keep the information of Buy Me confidential, to only be used for the purpose of evaluating whether to purchase Buy Me. After you investigated their businesses, Rapid Grow decides not to purchase. But you're intrigued by their preliminary development work using Teflon paint to reduce air drag. What can be done to take advantage of reduced air drag paint for Rapid Grow's bicycles? Yes, you do a search in hopes that you will find prior art that shows something very much similar to or identical to the use of Teflon paint to reduce drag. And if you do, then you don't have to worry about the confidentiality of this invention, because you can get that very same information from a publication that's not subject to a duty of confidentiality.
So you can do that even though that this company planted the seed as far as doing that?
Yeah, exactly you can, because if you find a piece of prior art that shows a bicycle painted with Teflon paint in order to reduce air drag, it doesn't matter. I can tell you to use a wheel the next time you make a car. And you've signed this confidentiality agreement with me. I can tell you, you can go out and make a car with wheels, regardless of the fact that I told you that to use wheels on a car, because it's known. That is not something that trade secret law will protect. They don't protect some concept unless it's in fact secret and not generally known. If it is generally known to the public, readily accessible, it cannot be protected as a trade secret, no matter what written words surround it.
If Teflon paint were used to reduce air drag in a different application, say like a car or something like that, would you still be able to?
That would be an interesting question to argue, whether bicycles are an obvious variation of cars, and it wouldn't be quite so clear, and so that would be more fuzzy. I'm not sure how that would come out, but certainly if you find prior art on bicycles, you're home free. If you find prior art on cars and tricycles, I think you'd probably still be home free. But if we don't have bicycles or tricycles or unicycles or anything pedal driven, then then they might argue that, well, people knew to use it on cars because they go really fast, but nobody thought that bicycles that only went slower speed would benefit from it, and they actually do. So, okay, there you go. Any other questions? I have a general question. This is not on a PowerPoint. Let's say I'm a company in Yugoslavia. I make widgets, and I want to sell them in the United States where there is a patent that would be infringed. If I do sell them in the United States, what are the remedies that the patent owner would have against me? What can they do? Where can they file suit against me? What are their options? I'm a Yugoslavian exporter to sell my widgets in the United States. What can they do to me, patent owner?
Would they go to the U.S. Customs first?
They could go to the U.S. Customs, well, normally the start would be in the International Trade Commission to get an exclusion order that would then be implemented by the U.S. Customs. So that's the path that you would do that. If you wanted to do that, what would be the result? You would just get an exclusion order if you're the patent owner. You can't get money damages. You just can get it prevented from being imported. That's the only remedy you get from the International Trade Commission. What's the advantage of the International Trade Commission? Yes, it's fast. Okay, what other option would I have if I chose not to use the International Trade Commission because I wanted money damages because the person is selling and costing me all kinds of money? And I wanted an award of attorney fees too, because I think what he's doing is wrong. He knew the patent was valid and infringed. I want treble damages, and I want payment of attorney fees. What's my option for that? Can I get an injunction against him? Pathway is the United States District Court, which will give me damages, and they may treble the damages times 3, and they may also give me an award of attorney fees if it's an exceptional case, if I'm the patent owner. And they may give me an injunction to prevent further sales if equity makes that a reasonable and fair outcome. Okay, well, I look forward to seeing you all, assuming I don't have jury duty. And if I do have jury duty, then you'll see some fine grad student here handing out